Okay, I think we're going to go ahead and get started here. Thanks for those of you that are still coming in. We are doing our workshop today with the North Carolina Bar Foundation, NC LEAP. We have Kristy Cook here, who's going to talk to us about best practices of contracts. Contracts, what are they and why do you need them? I want to thank, first of all, before we get going, I want to thank our partner organizations, Mountain BizWorks in Asheville, Prospera in Charlotte, and the Small Business Center Network for all of their support for making these workshops happen. We are grateful, and we're grateful for our presenters. Kristy Cook is here today, and I'm going to give the floor to her so she can talk to you about contracts. Thanks for being here, and enjoy.
Wonderful. Well, welcome everyone. I'm so glad that you're able to join us today, and I'm hopeful that this presentation will help demystify contracts. I know for a lot of us, they can feel very intimidating, and so it may feel like you just want to either avoid them altogether and not have them, or just sort of close your eyes and sign the document and hope for the best. So hopefully you'll leave today with some tools that will get you set up on the right foot. So as we're going through, we're going to have examples that you all can participate in helping me answer, and there will be points throughout the presentation where I'll pause and I will answer questions that come up. So please feel free to post those in the chat box. And when we get to those sort of natural stopping points, I will check in and go through all of them. So without further ado, go ahead and get started. So as my name is Kristy Cook, and just as background, I'm a small business attorney. I help small businesses launch and grow their businesses, and I also regularly support nonprofits. So contracts, as nerdy as it sounds, are near and dear to my heart. So with that, today we are going to tackle what even is a contract, how as business owners do we form them, how can you negotiate a contract, what should I include in my contracts when I'm trying to negotiate them and get them out the door? How can I terminate a contract that I'm in, or that someone I'm working with might want to terminate it? What does a breach look like? Are there landmines in these contracts that I'm not aware of? How should I manage my contracts as a business owner? And then we'll sort of wrap it all up with some common mistakes that I see that pop up when business owners are working through and with contracts. So before we begin, I just want to make sure that you all know that this is a super broad overview of contract law. Lawyers go through a whole year or more of contracts in law school, so that's a lot to try and fit into just over an hour. And so, it's not intended to be legal advice or create any sort of attorney-client relationship. And the point of all of that is to say, please make sure that as you start diving into contracts with your business or signing them, that you consult an attorney for your specific situation, because contracts may look the same or may look like a standard template, but they really do create specific obligations to us as business owners, and you need specific advice for them. So what is a contract? What is this magical term that we keep hearing about? Simply put, it is a voluntary, legally enforceable promise between two or more people or parties to either do something or not to do something. So that's pretty basic, just a promise between at least two or more people or parties to either perform some service, sell some good, or not do something. And they can be created really easily. There's three types of contracts. There are oral contracts. So yes, you can have a contract that is formed just with your words. There's an implied contract, and my favorite, and you will learn why by the end of this, are written contracts. So an oral contract, just as I described with the definition, is a promise. So you can very simply create a contract by saying, I promise that, to the little kid that knocks on your door, I promise if you mow my lawn once a week, I will pay you $20. And then he says, okay, I agree. I will mow your lawn once a week for $20. done. You have created a legally binding contract with your neighbor to mow your lawn. So how does that differ from an implied contract? Well, an implied contract is a contract that arises through our actions. So in that same example, if your neighbor, let's say for the first 3 months of the season, is out there mowing your lawn once a week as promised, and you're paying him once a week, and before he mows the lawn, there's nothing that says he has to check in with you or get permission or anything like that. He can just show up, mow the lawn, and you'll pay him the $20. So let's say you decide to go on vacation, and for some reason you don't want your lawn mowed during the week that you're gone, assuming COVID is over with, and you forget to let your neighbor know so that you didn't want him to mow your lawn while you were gone. He shows up, mows the lawn, and then knocks on your door. You're not there, so he waits and comes back and gets his $20 when you're back in town. You say, oh no, I was on vacation. I didn't want you to mow my lawn while we were gone. Well, the problem is, because you have, over all of this time, allowed him to show up and start mowing the lawn without asking for permission, you've created an implied contract that you will pay him just through your actions, okay? And then, of course, when we all think contract, I think most of us just think of the written document that promises, that creates promises and obligations between two or more parties. So I mention all of this so that you can keep in mind as business owners just how easy it is that you can get yourself into a legal situation by simply promising or to do something or not do something for your customers or vendors, for example, that you work with. So that leads me to this question. Should I then, if I can form a contract so easily, is my handshake good enough, or should I really take this extra step and get my contracts in writing? And of course, the answer is yes. And I'm not just saying that because I'm in the business of selling contracts. I am in the business of protecting business owners. And the reason that answer is yes is because a contract exists to remove uncertainty. A written contract, I should say, exists to remove uncertainty between you and the other person that you are contracting with. And so, I think that contracts get a bad rap, but if you could kind of flip the switch on them a little bit and instead think of contracts as a relationship preserver, okay? They exist so that when you are entering into contracts with your customers, your vendors, your best friend who's going to be your business partner, that if something were to go wrong in that relationship, you have a document that can help clarify, who's on first, what is supposed to happen in this particular situation. So you don't have to fight about it. And that's why contracts are relationship preservers. I really want you to think of them, in fact, as worst case scenario roadmaps for your commercial relationships. And just as an aside, some contracts must be in writing in order to be legally enforceable, but the number and types of those contracts is very small, okay? Especially in North Carolina. Here, basically just the purchase or lease of real estate, or when you're dealing with large loans and debts, have to be in writing. Everything else can be, written, or it can be an oral contract or implied. But as we've just learned, is that a good idea? I would say no. And, my aside here, number 6, is, well, what if you're working with folks who are kind of old school and, agree that a handshake is, your promise and should be good enough? Or if you have a template that you use and folks are objecting to entering into contracts with you, well, I would caution you to not go forward with those relationships, because if something were to go wrong, and I know a lot of people believe in Murphy's Law, if something were to go wrong and you didn't have a written contract with that person, you can expect that you're just sort of opening yourself up for a battle that maybe you wouldn't have had to be in otherwise. So when I say contract, again, just keep in mind it is a promise to do something or not do something between two or more people. So whatever we call it, as long as it meets that sort of definition, you've essentially got a contract. So whether we call it a professional services agreement, a lease, a non-disclosure agreement, an option to purchase, a memorandum of understanding, etc., all of these things can be and are contracts. So how then, what are the legal elements required to actually form a contract, to form that promise and make it legally binding? So all you need is what's called an offer, acceptance, and the sort of wishy-washy legal term here, consideration. If you have those three elements, you have created a binding, enforceable contract. That promise between you and someone else will be enforceable in a court of law. So what is an offer? Well, an offer is a promise to do something for another party in exchange for something of value. So all you have to do is say, the little kid, I offer to mow your lawn for 20 bucks. That's your offer. The acceptance is, I agree, that sounds great. Come every Wednesday and we're good to go. And consideration is simply that exchange of value. So typically in contracts, and it's an exchange of money, but it doesn't have to be. It just has to be something of value. Okay, so what each party is going to offer the other in exchange for the binding promise in the contract. So it can be, as I said, a payment. It can be a promise to act or not act, and a promise to do something in the future. So if you have an offer, acceptance, and this crazy term consideration, meaning just something of value, you will have a binding, enforceable contract. So let's put it into English, right? Which I know lawyers aren't always great at doing. So let's go ahead. Oh, and I did forget to mention, I'm going to pause really quick for this question that just came in. Yes, this slide deck will be available to all participants. All the materials and the freebies that I come up with today will definitely be emailed to you after this presentation. So you don't have to scribble down, ferociously through this. So example 1, Joe appears in Judge Judy's court claiming Mary owes him a bicycle. The facts of the scenario are simply that Mary said to Joe, I'll give you my bicycle tomorrow. That's the entire conversation. So based on what we've sort of touched on so far with offer, acceptance, and consideration, do we have a legally binding contract? Why or why not? So I am going to launch the poll. And if you just want to answer the first question, let's see what you all think. Do we think there was a contract? Why or why not? Did the poll pop up? No? Okay. Were you guys able, I can't hear anyone, were you all able to see that poll when it popped up? Oh, okay, it did. Okay, I'm gonna relaunch it. And there we go. Let's see, clear existing, okay, continue. Okay, try it again. Just the first question, yes or no, do we think that when Mary said to Joe, I'll give you a bicycle tomorrow, a contract was formed? Okay, so I'm gonna just go ahead and skip the polls, and if someone wants to chime in, I would love to hear what you think. Okay, no, not a contract. Okay, so you are correct. There is not a contract here, and the reason is because there was an offer. I'll give you my bicycle tomorrow. There's something of value, the bicycle, but there was no acceptance. Joe never said, I accept. Great. Yes, that sounds good. So because of that, there is no legally binding contract, and Judge Judy is going to send Joe on his way bicycleless. Okay. So what about this second example where Joe is back in Judge Judy's court claiming that Mary owes him a bicycle because Mary said to Joe, I'll give you my bicycle tomorrow if you pay me $200. Joe says, it's a deal. What do we think? Yes or no to this being a contract? I see a yes. Yeah, great. Exactly. We have an offer. Again, I'll give you my bicycle tomorrow. We have consideration if you pay me $200 and the bicycle. So each party is giving something up, and Joe accepted. It's a deal. So Mary is going to, assuming Joe is ready to pay, is going to require Mary to hand over the bicycle because there is a legally binding contract, a legally binding oral contract, I will say. So in this third example, same issue. And in this case, tomorrow when Joe shows up to buy the bicycle, Mary said, haha, your loss. I changed my mind. I'm not selling you my bike after all. Do we think Joe has any recourse? Yes or no? No recourse. So actually the answer here is yes. This is actually a carryover from example 2, because there was a binding contract. Then Joe does have recourse, and his recourse is that Mary's going to have to honor this contract and sell Joe the bike as long as he, is willing to pay. So he ended up in the right court, and he's going to be able to enforce this oral contract. So what if, we just talked about offer, acceptance, and consideration, but what if one or more of those facts or elements, I should say, are missing, as we saw in a couple of the examples? Are you dead in the water? Well, if you don't have a legal contract because you don't have offer, acceptance, or consideration, occasionally, under the law, one party may still be on the hook if they receive some benefit from another person, or promised that person that they would do something, and the person relied on it to their detriment. So again, the point of all of this, as complicated as it sort of sounds, is to make sure that you all are walking away knowing how easy it is that you can kind of dip your toe into forming some sort of legally binding agreement through your business, so that if you don't intend to do that, you can steer clear. So in this situation where you don't have a legally binding contract, there are times where, out of fairness, the law will enforce, or at least make a person who was relied on something to their detriment, will make them whole, even though technically a contract didn't exist. So these two concepts are called reliance and restitution. So reliance under the law, this idea of reliance, exists when a promise is made that caused somebody to act or not act because of that promise. Okay, so where somebody makes a promise to do something or not do something, and you could reasonably foresee or reasonably expect that your promise could cause somebody to act or not act, the court is going to enforce that promise just in a way so that there's not injustice to the person who was sort of damaged in that interaction. And this concept of restitution exists where an obligation is created and one party is going to benefit at the expense of another party. So now this doesn't include gifts, okay? The law is very clear in that a gift is a gift and is optional and is not going to be enforced generally. And you can't force services on someone, okay? But if somebody is benefiting at the expense of another and it is causing what's called unjust enrichment, which just basically means, wow, that was really unfair to the other person, the court is going to at least make you whole. So legal slide aside, what does that look like in real life? So example 4, Mary this time is knocking on Judge Judy's door, and she's claiming that Joe has to reimburse her for her apartment expenses. Now, why? Okay, so in this scenario, Joe has told his recently widowed sister, Mary, and Joe's a real piece of work in this fact pattern, that if she moves to North Carolina, he will provide her a place to live. So Mary, who just adores her brother, trusts him, and moves to North Carolina from California. So big move, right? She doesn't tell Joe, but she's relying on the promise that he made, assuming he's going to expect it. And when she gets to North Carolina, she knocks on Joe's door and he says, "Whoa, what are you doing here? I'm not going to give you a place to live. Sorry, you're out of luck. Figure it out yourself." So the first question we have to ask is there an enforceable contract in this situation? What do we think? Maybe a second. If you want to just pop the answer into the chat, feel free. Okay. Give me another second. So in this situation, do we have an offer? Yeah, Joe offered, "Hey, if you do this, I'll pay for your apartment." Cool. Is there consideration? Well, yeah, he's saying he'll pay for her apartment. There's an exchange of something of value if she'll move. And for her, she's, okay, she'll move. But do we have acceptance? No, Mary never said, okay. In fact, she didn't even tell her brother she was coming. So we don't have a binding contract in this situation. But doesn't this just feel really unfair? It just doesn't sit well, right? So based on sort of that previous slide, is there some other remedy available? And the answer is yes. Judge Judy is probably going to say that Mary relied on her trusted brother and his promise that if she would relocate, given her change in situation, that he would help her and find her and pay for an apartment. And because of their relationship, let's say, it was foreseeable that Mary would trust him. This is her brother. And so it was foreseeable that with his promise, she would move across the country. So because of that, Judge Judy is going to say, okay, Mary, we're not going to, because there's no contract here, we're not going to put you 10 steps ahead. You're not going to be able to, live in a 5-star apartment by any means, if that's not what you're living in California. But I am going to make you whole. So you gave up all these things to move here in reliance on this promise. So Joe needs to follow through and give her or rent her that apartment just to make her whole. To make her whole, Joe's going to have to pay for the moving expenses, right? So that basically when she gets here, even though there was no contract, when she gets here, she will not have been in a worse off position than what she was in California. So those moving expenses and all of those things will likely be reimbursed to her because of this idea of reliance. Okay. So, and the reason is because it was foreseeable that Mary would take this step based on his promise. So let's look at another example of this issue. In this case, Mary's back in Judge Judy's court claiming that Joe must pay her for watching Joe's elderly mother, Ruth. In this case, Joe asked Mary, who is his best friend in this situation, to help him care for his elderly mother, Ruth, when he has to go out of town. Mary agrees and stays with Ruth for 3 days, 24/7, during which she bathed Ruth, fed Ruth, took care of all of Ruth's needs. When Joe gets back, he's like, "Oh, Mary, you're the best. Thank you so much," and sends her on her way. Mary's flabbergasted because she expected that Joe would compensate her for all of that caregiving time. So do we have an enforceable contract? Well, there wasn't really an offer. Sort of. It was an ask. Mary did accept by showing up, and there was definitely, there also arguably wasn't consideration. So in this case, though, but doesn't it seem super unfair? Mary put her whole world on hold for 3 days and was working her, tush off to help Joe out. And so in this case, the court is going to say, Joe, this is not cool. You're going to need to make Mary whole and pay her restitution because you were unjustly enriched at Mary's expense. You were, received this huge benefit at poor Mary's expense. And there's nothing about this fact pattern that seems to indicate that Mary intended this to be a gift to Joe. So in this case, what Judge Judy is going to award is compensation to Mary in the fair market value of her services. So they're going to look at sort of what a caregiver would charge at sort of market rate. And that's likely what they will require Joe to pay Mary, just out of the sense of fairness and equity. So even though there wasn't a contract, the law isn't going to reward people taking advantage of each other on sort of a technicality. So I'm going to stop there. There's a lot to take in. That's like, 3/4 of your first year of law school in those few slides. And just ask, do we have any questions? You can drop them in the chat. You can call them out. What do you think? And I'll go back and double check. Do I see any recording? Okay. Well, I don't see any, but feel free to shoot them over, and I will, if you think of something as we go along. Okay. So that's the really heavy, hard stuff, and we're gonna let that kind of sink in, and you'll have these slides you can go back to. And now let's talk about, how do I negotiate a contract? Now that I know what a contract is and how easy it is for me to step into one, and the fact that it doesn't have to be in writing, I could still accidentally be creating a contract, or if I've given somebody some, indication that they can rely on my promise, I could also be setting myself up for something here. So how do I negotiate a contract? And I really want to empower you to know that almost all contracts can be negotiated as a business owner. And worst case scenario, if you try to negotiate and the party you're negotiating with, worst case scenario, they say, no, I'm not changing this contract, take it or leave it. Okay, well, at least now I know, but I tried. And sure, if you're entering into a contract with some mega vendor like Amazon or Office Depot or something like that, they're not going to negotiate on terms with you. But if you're hiring vendors and small businesses and your customers may even try to negotiate with you, just know that you can always ask. Okay. So also, the other thing that I want you to know is if somebody is handing you a contract to sign, before you even read that contract, you know that if they're handing it to you, that contract is written in their favor, okay? So you know that you need to read that with a critical eye, because chances are, even fair contracts, the person who drafts them is always got a leg up. So, you really, really do need to look through them. And I really encourage all small business owners, get a book. There's tons of books out there that you can get that aren't, super dense reading, that can really help you just kind of develop these reading skills to kind of at least know where your red flags are. So, and we'll touch on that just a little bit through this, but again, it's a lot to go through. So definitely, check out a book like that. So when you are negotiating a contract, some tips that I have are to make sure that you are being professional and courteous and reasonable. People who kind of go in and try and strong arm their opponent in these agreements usually don't do very well in trying to get what they accomplish. With your body language, if you can portray a positive attitude and mindset and know that you can walk away from this deal if necessary, that's very empowering, and that can be communicated through your body language. Try and relax and smile and keep your feet planted, because I know sometimes it's nerve-wracking asking for folks to cave a little bit on their terms. And get the other side talking. The more you can let somebody in a negotiation do the talking, the more they're going to like you, and the more they're probably going to trust you. And the more you'll learn about them, which will help you negotiate with them, because you'll better understand the carrot that you need to give in order to kind of come to a middle ground. Listen for clues about what they might be willing to trade off on and issues that may be a sticking point for them. And then also think about that carrot that you can toss into the ring, that, maybe you start higher in your negotiation than what your ultimate, walk away point is, just so that you have room to give in that negotiation. So it's helpful along that same vein to raise one or two issues or concerns that are secretly of lower importance than others to you. Those become your bargaining chips, and that are going to help give you some strategic leverage to really get the things passed through this contract that are important to you. And really, the number one thing that I want to give you as a tip in negotiating is don't negotiate against yourself. And this comes back to try and listen more than what you're talking. Don't just go in and start offering because you're nervous. Start offering concessions in exchange for nothing. Let them do the bulk of the talking if you can do it. It's hard. It's very hard to be the listener. I understand that. And also, really beware of confidentiality concerns. In your negotiation, are you giving Are you going to have to share with them any of your trade secrets, your know-how, things that really matter to your business that you want to protect? Or vice versa? In that case, you probably want to sign some sort of non-disclosure agreement so that you can freely communicate without fear that they're going to sort of, tell everyone your secret sauce recipe, right? And then the number one thing in these negotiations and in asking people to sign contracts in the first place is please, please, please don't let someone accuse you of nitpicking. Silently accepting terms that you don't understand or that you don't agree to or that could be problematic for the security of your business, which you have dumped your heart and soul into, is going to carry greater risk for you than if you had just spoken up and mentioned it to see if you could work out the details to make it a little bit more reasonable. Again, it's better to be guarded and cautious than to assume the other party knows what they're doing or that they care about your interests, even if they're your best friend. In a contract situation, most folks in business are starting from a place of self-interest, okay? So, I think too, if you're reading through a contract and you come across a sentence or paragraph or something that you do not understand, don't sign it. Figure out what it means, because it could be some major sticking point that could cause headache for you later on. And it could be a typo. I'm now at probably my 5,000th contract that I have reviewed and or drafted in my career, literally. And I cannot tell you the times that I have seen these contracts come through where, even from big vendors, they're just riddled with typos that no one caught because no one's looked at the template in 10 years. So don't be afraid to ask questions in the name of protecting your business and all that you've put into it and worked so hard for. And again, remember, contracts are relationship preservers, so it behooves you to get it right before you sign it so that you don't have issues later on with preserving that relationship. So I saw a couple questions come in. Is it worth the court costs for these contracts? So I think what you're asking, well, it could be two things. Having an attorney draft your contracts, you can think of as almost same way as in getting insurance for your business. Yes, you're paying up front for something that will hopefully help you reduce liability exposure later on. So if that contract is doing its job, hopefully you never get to that point where you're spending a ton of money on cases. And then also, the question could be interpreted as well. Can you, in enforcing contracts, is it worth the money to even take it to court in the first place? And yeah, court should be, and we'll talk about in a minute, the last case option, the last case scenario for all of us in trying to enforce a contract. For a lot of small businesses, contract disputes are likely going to be handled in small claims court, which is not a lot of money to go to. Certainly there's risk, but yeah, depending on, some people fight contracts just out of a sense of justice. Some people fight it, just because there is value. But yeah, all of these fights are a balance of, risk reward that whoever's upset has to think through. So another question came in. Other than this webinar, is there any workshop or event where we can have our small business contracts reviewed? So, in North Carolina and all states, only licensed attorneys can give legal advice on documents, which is what is involved in reviewing contracts. But there are the bar has plenty of pro bono opportunities, I believe, out there. that you can, possibly seek out, or reduce cost opportunities. And I'm sure the foundation can speak to that as well, either through the chat or maybe towards the end of the presentation. It's a great question. Okay, so what should be in a contract? And we will sort of fly through this a little bit, but just know that the goal of a contract is to make it as comprehensive as possible. When in doubt, put it in the contract, again, because contracts are relationship preservers, right? So what I like to do, my approach, and this is a learned skill. This isn't that, law school is sort of like, oh, I went to law school so I can do this now. No, this is because I've looked at thousands of contracts. The learned skill is that when you're going into a contract, you have to think about what is the worst thing that could go wrong under this agreement. And if it were to happen, God forbid, which hopefully it wouldn't, but if it were to happen, is the contract written in a way that it explains how we have to handle that situation? Okay, so, you're not going to be able to address every possible situation in your contract, but the more you can think through those things up front, the better off you'll be. Again, always assume that the others have read, and the other thing is that you want to make sure that you are assuming, if this contract ends up in court, is the judge going to be able to understand the deal and our intent and what we agreed in this? Because they're only, and this is what this parole evidence rule thing is, just a fancy way of saying that a judge is only going to look at the face of the contract to decide how to rule on the dispute, okay? And only in limited situations, such as, if there was fraud or duress involved, both parties were mistaken in the contract, the terms are ambiguous. Only in those very rare situations, which don't happen very often, will the judge be willing to consider outside evidence to interpret what an agreement says. That's why anytime now going forward, you probably haven't noticed up till now, because why would you read the boilerplate? But when you scroll down through a contract, usually some of the last paragraphs you'll see is some clause that says entire agreement. And that clause is there to say that this written document supersedes all other discussions, memos, emails, any sort of conversation that we had to get to this point. And this is the only document to be considered. Okay, so that's why it's so important to make sure that your contract is as comprehensive as possible and removing any gray areas, because the judge isn't going to allow in outside evidence to interpret that contract if something goes wrong. Okay, so when things go wrong, in the way the judge is going to look at the face of that contract, they're going to look first, and this is sort of in order of how the judge will look through the document, at the plain meaning of the words that are in the document. What is Webster's dictionary? How does it define, this term? If it's a technical agreement, they will look then to the technical words and sort of the technical dictionary. Then they will start looking at the intention of the parties. That's why you always see at the top of a contract a section that says recitals, because that's intended to let the people know what the goal is of the document. Is it consistent with that general purpose? Then maybe they'll look at surrounding circumstances and reasonableness, okay? And then, the course of dealing, in the simple example of the kid who was mowing the lawn. Well, what was the course of the dealing? And that course was that he showed up every Monday and mowed the lawn, and you paid him. So you will continue to have to pay him on the Mondays that he shows up, okay? So now what I'm hoping and what I'm going to give you is what I've created as this contract review checklist. And again, this will be in all the materials. What I've tried to do is take these terms, and let me share this with you. Okay, you should see the contract review checklist now in front of you. And so what I've done here is I have taken the common paragraphs that you see in a contract, and I've either given you an example or tried to define what the point of those paragraphs in English is. Now, you don't see these paragraphs in every single contract, but you will see them in a lot, and a lot of them will have similar titles or headings. And my hope is that this can give you a little bit of a map to be able to say, okay, what the heck does force majeure mean, and what is the intent of that clause? And you can come here and you can see that the point of a force majeure clause is to spell out when and to what extent a party's performance will be excused if someone can't perform because some event, pandemic, happened that was beyond its reasonable control. This force majeure clause was on everyone's lips when the pandemic hit to try and figure out how they were going to suspend contracts or get out of them. So hopefully you can, go through this and you can read it early and in advance. But my hope is that this will help making reading a contract a little bit easier, at least so that you understand the intent of each of these paragraphs, particularly, these paragraphs that aren't clear, like, okay, term and termination. I think on its face, we all kind of get what the point of that paragraph is about. But what the heck is a representation and warranty, or limitation on liability, or indemnification? Sort of all of these fancy paragraphs, these fancy names. These are the ones that folks are relying on when things go wrong. So indemnification, for example, is going to talk about who gets protected in this dispute when things go wrong, okay? Or limitation of liability, which is super important. And that paragraph exists to say, okay, if something goes wrong and I'm held liable because I've somehow damaged you, I will only have to pay X number of dollars, or I will only have to perform X number of services. It limits your exposure. So hopefully this can be a little map for you going forward that you can read in conjunction with those books that you get. And there are some very easy, straightforward books out there that you can get from any sort of bookseller on small business contracts. Just get one. They all say the same thing, and you can really have a leg up in your contract negotiations and reading them. Okay, let me get back into the presentation. And so what should be in a contract? Again, clarity is king. The clearer you can be in a contract, the better, because you're gonna, your goal should be to fix unclear and confusing language, remove unnecessary or inapplicable provisions. A lot of times folks will just have a template they make everyone sign, and it may not be applicable to the agreement that you're actually entering into. So strike anything that's not applicable, because it could cause problems later. You want to correct internal inconsistencies, or is one word used this way in the top of the contract and then used a different way later on? And when you're thinking through, is my contract complete? When I'm thinking through every sort of worst case scenario, these questions I'm hoping can help you answer that. Okay, so ask yourself after your contract, is it clear what we're trying to accomplish with this contract? Are both of our obligations and the services that we're supposed to perform or not perform spelled out? Is anything left off that we need to include? Does the agreement specify what's going to happen if the other party fails to perform, fails to follow through with their promise? How can we terminate and get out of this contract if neither of us or one of us doesn't want to be in it anymore? Are there any terms that are going to survive this contract if it terminates? Meaning, even though the contract is done, will I have obligations that sort of continue on forever, like confidentiality provisions? And if so, what does that look like? How are intellectual property rights addressed? So intellectual property are things like our trade secrets, our trademarks, our copyrights, any of this stuff that's really the secret sauce of our business. How are we going to protect that? Is it spelled out that it will be protected in the contract? How are we going to solve disputes if they arise? Super important, right? We've already talked about all the reasons why. And what payment is due and when, and in what increments, what deliverables have to be provided before I have to pay my contractor, because I don't want to pay him or her if he didn't meet his obligations, right? So answering these questions in each of your contracts, and again, it just takes practice and it will sort of become automatic for you. But it's going to give you a leg up, and it's going to really help you use contracts to their fullest in protecting your business. Okay. And you also, to answer these questions, really have to understand the risks that you can be exposed to through your business. And again, that's really just thinking about, worst case scenario, which is not a fun thing to think about, but it's going to help you. It's an exercise in preserving your business. So how do we get out of contracts? Sometimes we get ourselves into things and we're like, oh my goodness, I wish this would be done. I can't believe I have one more year left on this thing. So you can terminate a contract based on whatever the terms are. Hopefully there are termination clause in your contract. And you want to follow that to a T. If there's notice requirements, things like that, just check off the list of all the things that you have to do to get out of a contract. Because if you don't follow those steps and you just fail to perform, then you will have breached your contract, okay? Unless, somehow that contract was invalid, or maybe it wasn't a contract to begin with, as we saw before. But you don't want to breach a contract, because that's when you end up in court, okay? And then again, we saw that the goal of the remedy in contracts is to put the injured party in a position where they would have been if the contract was performed, plus any other sort of reliance or restitution damages, like the cost of moving across the country and so forth. And so you don't want to be in the position of having to pay those things out, because damages can be large in those cases when we're talking about business operations. Okay. So, for example, Mary, this time, she's out of Judge Judy's court. Okay. She is appearing in district court because her damages are substantial. And she's claiming that Joe breached their contract and owes her a ton of money because of it. So the scenario here is that Joe is a parts supplier and he delivers defective parts to Mary. Mary is an auto manufacturer and she puts those parts in the automobiles that she sells. And, because she's not the expert in the part that Joe is selling her, she doesn't catch the default, puts them in the vehicles, and then finds out about them later because, cars are breaking down, or maybe someone's, in a horrible accident. Either way, she now knows about the defect, and she's in court trying to get Joe to make her whole for all of her damages. So the question then, if we're thinking about this, what the heck could Mary's claims be against Joe? What could she recover from him as far as damages are concerned? And so when you're thinking of this, the point of this example is to sort of illustrate the snowball effect of contracts. So, So in this case, we're talking about, and because now there's this, think about, if you remember back the Toyota case, right? There's this defective product on the road, and it's a high risk product where people can be injured. She's got to pull them all in and repair all of them and get them so they're safely operational again, which, as you can imagine, is a really expensive endeavor. So in this case, she's going to be able to not only have Joe refund her for the amounts that she paid for the parts, but Joe's also going to have to pay for any costs that were associated with recalling and fixing the vehicle with replacement parts. He's also going to have to pay for costs and expenses relating to any customer lawsuits from folks who were damaged by these vehicles. Regulators could get involved too and slap some fines on that he's going to have to reimburse her for. He's going to have to pay for any lost profits that she suffered having to sort of shut down her operations to get these cars back to her. Potentially paying for damages resulting from the bad publicity. And so obviously this is a huge, huge, huge issue. And my point in including this example, which I get is beyond a small business's operations usually. But the idea is that this is why the limitation on liability clauses in contracts are so important, because it is very difficult to sort of envision all the possible worst case scenarios. And that acts as your catch-all to sort of put a cap and a stop on the bleed when something goes wrong. Joe, let's hope, didn't intend for this product to be have malfunctions in it. Let's assume it was some human error, which does happen. And so that's the benefit of the limitation of liability and why you should pay extra attention to those in contracts and make sure you understand what that cap is, or just make sure that there's language in the contract that allows you protection. Okay, so again, with breaches, we talked about this. The goal should be to always avoid going to court. And, breaches don't have to be intentional. They can be accidental. They can happen, as we saw in the last example, potentially through no fault of your own. You always, if there's a chance you're going to not be able to perform on your promises as a business owner, get on top of that early. Tackle it as soon as you can, because if you put your head in the sand and ignore it, it's going to get bigger and bigger and bigger, and may get to a point where there's nothing you can do to rectify the situation, and you're going to end up in court. Okay? And the same thing with the people you're contracting with, your vendors. If they're not performing properly under their contracts, get on it right away. Because the longer you let it go, the harder it is to justify that they should have performed that way to begin with. And so, these small businesses of yours, I'm a small business owner, I own my firm. These are our babies, right? And so when things go wrong, it feels very personal, and I understand that. And that's the other reason why I stress the importance of having these written contracts and using them as relationship preservers, because you don't want to have that ugliness if you can avoid it in your life. But if it does happen, the best thing that you can do, as hard as it is to keep your emotions in check, see a way to resolve your problems quickly and informally. Maybe if you've got some staff, see if your frontline staff can maybe work it out amongst themselves. And then you can take over when maybe things aren't working that way. But the process here then, as you can see under C, is sort of the escalation steps. Then you're in this point where you might be exchanging demand letters, bringing in a mediator to help you get through something. And then, only worst case scenario is to file a lawsuit, because they are expensive. They derail your business. They are a time suck, and, they're just personally draining.
We may have lost Kristy for a minute. Hang tight for just 1 second. She said that her internet was acting just a bit glitchy this morning, and we were hopeful to get through it. So if you just can hang out for 1 second, bet she'll come right back. Thank you for your patience with this. I know that some of you probably had a couple of questions and wanted some to finish up with the points that she was making. So just hang out for 1 second.
Okay, back.
Kristy, I kept him company for you while you were gone.
Okay, thank you. When did it cut off?
Probably about a minute before you.
Perfect.
Yep.
Okay, and I'm going to stop my video just to help it. So I was explaining to Paul earlier that, oh, you'll have to make me a host, Paul, that they are doing construction type stuff outside my house. And so it is keeping us from being able to, there we go, have the best internet at all times. Okay, let's go back in. And play from current slides. Okay, so hopefully you saw we were just talking about breaches, and the moral of the story there is to stop them before they begin if you can at all. Get on top of those contracts, and when things start going wrong, try and tackle it and make it right so that it doesn't turn into some massive dispute. And you can also try and renegotiate contracts too if they aren't working well for you. That's a great tool, which I didn't include on that slide, to try and help resolve an issue. So once you're an owner and you are contracting with customers, vendors, your landlords, lenders, if you have a business loan, you're going to start accumulating contracts. What do you do with them? How do you stay on top of all of them, especially if you're not using your own templates? A lot of businesses you'll see will use templates and insist on using their own templates, really is a matter of managing contracts so that they sort of know from agreement or relationship to relationship what the general terms are. So let me open up the chat again and make sure to see that. So one tool that so when we're talking about how we can manage our contracts, it's important, especially if you start bringing on employees, that you have a contract policy in place that defines who in your organization can legally bind your organization. So who can sign contracts? Is it tied to how much they're allowed to spend, their spending authority, for example? As owner, do you want to see all the contracts, right? So that's what the purpose of the contract policy is. And then how they get processed in the first place. Okay, what does your contract review process look like? What are the terms that you expect to be in all of your contracts? What terms won't you accept? For example, you'll see a lot of dispute resolution terms that are saying, oh, if a dispute arises, you will handle this in California. Well, I don't have the funds to go jump and go to California if something goes wrong with this agreement. So no, let's change that to North Carolina. And so these are the things as you're growing your business, or even if you just have an army of friends working with you, it's important that you know who's got roles when it comes to contract processing. Okay. So another freebie that I have is, let me share this with you. Okay. is this data tracking list. And again, just like the last example, this is sort of all inclusive, and in no way do you need to track every single one of these data points. But what I'm hoping this list will help you do is to identify the stuff you really care about tracking in your business. You know, for example, start date, end date for contracts, that's usually very important. And those sorts of things. You know, you can have an Excel sheet, Airtable, whatever way you could write it out by hand, although I don't really recommend that. However you're tracking these data points, these are things that you can think about with regard to what's important for you to track in your business, in your particular industry. It's different for everyone. So you have sort of formation type terms that you see in the contract. Performance, I would expect that a lot of us would want to make sure that we're tracking deliverables or milestones and deadlines. And then how we close out a contract, how can it be terminated or breached? Those sorts of questions are things that you can just have one central database to manage your contracts. And as silly as it sounds, you know, even if you just got one main contract, let's say your lease for your business, start with that. You know, lay this groundwork early so you're just building on it and you're not having to unscramble an egg 3 years down the road when your business really starts flourishing, or hopefully sooner than that, but you understand what I mean. So again, this will be in the materials that you'll get in that handout. It's these 2 freebies are at the very end of the PowerPoint presentation on the slides that you'll get. And as we wrap up, just some summary of the common mistakes that I see. Huge issue is where folks start performing their obligations under the contract before they have the contract signed. I can't tell you how many times I've seen folks start work because, you know, they thought things were going to go well, and then they just can't work out the terms of the agreement. And now they're stuck fighting over whether or not they should be compensated for the work that they did, even though they're never going to get to a signed contract. And that's where that sort of reliance piece comes in that we talked about earlier with Mary when she flew across the country. Failing to shop around, it's okay to get bids. You are going to be business owners or are business owners. It's okay to shop around, even if one of the vendors you want to hire is your best friend. You know, try and get the best deal with the best terms for your business. Again, we talked about clarity is king in these contracts. So making sure that you have strong performance descriptions in your contracts, meaning the scope of work is fully fleshed out, including those remedy terms, you know, what happens if something goes wrong in this contract. Making sure, you know, it's a huge mistake not to limit your liability, as we saw with the car manufacturer example, as an extreme example, but because that hopefully it will stick in your mind, or allowing the other party to place too many limitations on their liability given the risk associated. Maybe you're a general contractor and you hire subs who, you know, are doing super risky work because it's construction. Don't let them limit their liability into sort of non-existence. Poorly vetting your vendors, as we saw again in the car example, as owner, you're going to be on the hook for all the stuff that comes from the people in your supply chain, right? If you have a vendor that does something wrong, you're the person that's customer facing. You know, I know a lot of us, when we're starting our small businesses, bring on independent contractors to help us, and maybe they're interacting with clients and stuff. Well, if we haven't vetted them well, that's our reputation. We are entrusting our baby, our business, in their hands. So please vet the people that you work well with, because at the end of the day, any problems are going to come back and sit on your shoulders. Again, we talked about the importance of negotiating contracts. So blindly accepting standard contracts is not going to be great for your business in the long term. You have the ability to negotiate. Again, worst case scenario, the person you're trying to negotiate with says no. Okay, cool. You learned, right? Having the wrong duration. So, you meant for a contract to be 6 months and it ended up being 3 years. Big deal, right? Not managing your contracts well. So a lot of contracts you'll see with vendors that you hire have automatic renewal provisions, for example, in there. So if you're not managing your contracts, you could just be renewing these things without intent and you miss your window to cancel them, for example. And then as you grow and start developing policies and procedures, failing to follow those could, or your staff failing to follow them, could really land you in, a place you don't want to be. So that's my presentation. And, I think generally, I just want you to know that I wish you every success in your business. There are a lot of resources out there to help small businesses that are either free or discounted. I think I saw some mentioned in the chat before things kind of went kaput. But that said, does anyone have any questions? I'd love to open it up.
Kristy, this is Kim. There is a question in the Q&A. It is, if someone has a parent company and the child company is the one that someone sues, can they essentially go after the parent company and all else under it, such as having an LLC as your umbrella and other companies under it?
Yeah, no, great question. So yes, it sounds like you've set your business up right, where you have a parent and then you have created what it sounds like are multiple, let's say, LLCs underneath that entity. So the point of doing that is to separate out that liability exposure. And so the liability, assuming that all those businesses are being run well and in accordance with corporate formalities, which is a whole other course, then they should not, if something goes wrong under one of those, they should not be able to come back to the parent. Now, with contracts, there could be an instance where let's say it's a loan or something, where the parent company had to provide some sort of guarantee in the document for the subsidiaries, then absolutely they can come back after the parent. But that should be fairly obvious in the contract if there is some sort of guarantee involved. Great question.
Thanks. Does anyone else have any questions to post into the chat or the Q&A? All right. It looks like none. But to let you know again, we will be sending out the PowerPoint and other materials, as well as a link to the recording of this webinar for you to access. We're really grateful for all the attendees. We're super grateful to Kristy for her time and sharing her expertise with us. And again, if anybody has any questions or any other needs, feel free to email us at the email address foundation@ncbar.org. Thank you again, Kristy and everybody.
Thank you. Good luck, everyone.